Big thank you to Mr. Paul Hayes. Very interesting presentation and definitely something for us to ponder about. I would like to see a day when Malaysia can actually become the hub, the regional hub for sporting arbitration. If we can plan it, I believe Malaysia boleh, we can do it. Our final speaker for today, for this session today, is Mr. Aziz Ibrahim, who is a well-known personality in civil litigation and dispute resolution in the corridors of our Malaysian bar. Mr. Isa, I'm privileged to say, is a close friend of the firm of Richard Wee and Yip, and is a respected senior advocate and solicitor, having been in active practice for approximately 20 years. Mr. Isa is an avid and active sports fan who has, since his admission to the bar, has without fail represented Malaysia in our annual annual bar games with Singapore. In his role as a senior member of our Malaysian Bar Sports Committee, Mr. Iza has led our Malaysian Bar to the 13th Lawyers Football World Cup in Turkey in 2006, as well as the first Asian Lawyers Football Cup in Bangkok in 2007. In his legal practice, Mr. Isa is a partner with the firm of Messrs. Ranjit Hui and Robert Lau, one of the premier firms in Malaysia, where Mr. Isa focuses his main areas of legal practice not only on sports law, but also on various areas such as construction law, corporate and commercial disputes, banking, defamation, and general advisory work. Mr. Isa is also an arbitrator and a mediator, a man of many talents. As a Malaysian practitioner, Mr. Isa has had the unique experience and opportunity of having appeared twice before the Court of Arbitration for Sports in Lausanne, Switzerland, to represent Malaysian sports bodies on matters such as the eligibility of participants to compete at the Beijing Olympics of 2008 and disputes between parent federations of a major Olympic sport and its member countries. Mr. Isa has been kind enough to be with us today to share his experience on dispute resolution in sports from a Malaysian point of view, our Malaysian flavor, so to speak. So, without further ado, let's welcome Mr. Isa on stage with a big hand.
Thank you, Mr. Yip. Judging by what Mr. Yip said about me, I must say I was a bit surprised. I didn't know I did that much over the years. But anyway, I think Justice Ma and Mr. Paul Hayes have actually stated out quite a fair bit of information which I find very interesting and very informative. And for me to stand up here, I don't think there's much that I can add, except for how I got involved and how each and everyone, I see quite a few practitioners here who can actually get involved in sports law. I, for one, when I started, never envisaged or never thought that I would be doing parts of sports law, apart from the fact that I'm a self-admitted sports jock. And once I have the remote at home, the remote of the television at home, that's it. It's only on the sports channel. Right? And my involvement in sports has actually, it started out way back in primary school and even through varsity and even at the Malaysian Bar. In fact, as a young practitioner, I wanted to get involved in sports activities in the bar. And in '98, I was on the sports committee. I took over football, my main sport. Since then, I decided to venture into other areas because at that time, although I was actively playing, there's only, no one's, I can't say I'm Peter Pan and continue playing for the rest of my life. So, but the interest and the ambition to still be involved in sports somehow kept this going, and that's how I got involved. And in 2008, I was fortunate enough to actually have been appointed to be in a legal advisory role with a particular world body of a particular sport that was based in Kuala Lumpur. And it just so happened, and I'm quite sure Paul can confirm that during Olympic years you will have many cases in relation to eligibility especially. And to tell you a story, my first case in sports law at the Court of Arbitration for Sports was actually in relation to participation in the Beijing Olympics, which, if I may just share with you, this, I was surprised when I got the brief because this is in relation to two athletes from America who, by how they have taken the matter up, they were really keen to participate in the sport in the Beijing Olympics. And to some, this may sound a bit trivial and it may be, it doesn't make sense, but this is exactly the argument that their lawyers actually based in their appeal to the Court of Arbitration for Sports. And they based it on a particular section of the Olympic Charter which states that the practice of sport is a human right. Every individual must have the possibility of practicing sport without discrimination of any kind in the Olympic spirit. And this is what they base their arguments on. I mean, a little fact of this case is that this particular athlete was ranked quite low in the world rankings of this particular sport. They took part in the qualifying trials of their own national body. They didn't qualify. They appealed to the Continental Federation. Again, it was dismissed, and finally they brought it up to CAS. Although it may sound trivial, but at the end of the day, both parties had to go through the motions, and although I would say that the result was actually just a logical conclusion, but parties still had to go through, and this was my first experience in dealing with the CAS matter, which is, at first glance, it was rather daunting. In fact, I thought that getting involved in it, I've done numerous domestic arbitrations, and this was my first attempt at trying an international arbitration. And to all the young practitioners out there, I mean, it is not very difficult. It is not very difficult, and I think Justice Ma and Paul has stated that your basis is actually in the law of contract, law of association, law of contract, and there's nothing new or anything unusual or difficult about it, in the sense that perhaps, yes, you may have to put in a bit more effort to learn the rules of procedure, of which when at that time, I don't know whether it's changed, because to be honest with you, the last time I did a CAS matter was a couple of years ago. I think it was in 2009, and at that time, strangely enough, that correspondences still had to be done by fax, and I don't know whether that's still the position. And we had to, due to the time difference with Switzerland, I had telephone conferences at 10 o'clock, 11 o'clock at night. And imagine having to fax through your submissions, which was probably going to be something like 70 or maybe to 100 pages long, and waiting at a fax machine to make sure that everything goes through. I mean, it was strange at this day and age that I did specifically request that can we do it by email or anything, and they said, no, please fax it through. So I don't know whether it's changed, but since then, I hope it has. It has. Okay. Now, in the Malaysian context, I cannot say that I've done many cases involving Malaysian sports or Malaysian sportsmen. Well, there have been several, which has been taken to court or to arbitration. Quite a few of these matters have actually been resolved, mainly because the nature of sports in this country. Because I do believe that one of the major issues affecting the development of sports in this country is professionalism, which we wish that it could be much higher, but at the end, there is still much more room for improvement. And most of the matters that I have had to go through is actually to merely advise, and I think even before that, as what Justice Ma has said, that I think the practice of mediation has long been taking place in this country. The only difference being is that, in my personal point of view, is that the nature of sports administration in this country is that perhaps, maybe, the athletes, the people involved in sports, and just like the typical Malaysian society, which I guess they're not very litigious, and therefore, and that's why perhaps mediation on a fairer level, or where both parties can be said to be standing on equal terms, should be practiced in this day and age. Because more often than not, you get situations if athletes are not happy with their sporting associations. Perhaps if you voice out the problems, and the athletes will be considered to be trouble athletes, and which may affect their future. I mean, this is the feeling, the feedback that I get, especially when they feel that they've come to you, they say, "I've been wrong by this association, I've been wrong by that association." And when you advise them that, yes, you can take action, but they will say, "But will this affect my participation in the next or the forthcoming games or whatsoever?" So they are always very worried about that. And in that sense, I would think that the answer lies in, I guess, in education and improvement in knowledge of not only the athletes and also the professionalism in the administrators and the general administration of sports in this country. Right? I've been told that, I do actually have quite a fair bit, but I would rather, and I think my fellow speakers would also feel that we would like to take some questions from the floor, and because in terms of, shall I say, the good stuff, the textbook stuff, I think has been competently covered by Justice Ma and Paul. With that, seeing that we are rushing for time, I think I would like to just be prepared to answer any questions that you all may have. Right. Thank you very much.
Thank you, Mr. Isa. Right now we'll have our question and answer session. We are unfortunately running a bit behind time, so we'll keep this, try and keep this as, we'll try and field as many questions as we can for today. May I first of all invite the speakers on stage, please?